International trade law includes the appropriate rules and customs for handling trade between countries. However, it is also used in legal writings as trade between private sectors, which is not right. This branch of law is now an independent field of study as most governments has become part of the World Trade, as members of the World Trade Organization. Since the transaction between private sectors of different countries is an important part of the WTO activities, this latter branch of law is now a very important part of the academic works and is under study in many universities across the world. Overview: International trade law should be distinguished from the broader field of international economic law. The latter could be said to encompass not only WTO law, but also law governing the international monetary system and currency regulation, as well as the law of international development. The body of rules for transnational trade in the 21st century derives from medieval commercial laws called the Lex Mercatoria and Lex Maritima respectively, the law for merchants on land, and the law for merchants on sea. Modern trade law began shortly after the Second World War, with the negotiation of a multilateral treaty to deal with trade in goods, the General Agreement on Tariffs and Trade. International trade law is based on theories of economic liberalism developed in Europe and later the United States from the 18th century onwards. International trade law is an aggregate of legal rules of Euro international legislation Euro and new Lex Mercatoria, regulating relations in international trade. Euro international legislation Euro international treaties and acts of international intergovernmental organizations regulating relations in international trade. Lex Mercatoria, the law for merchants on land. Alok defines Lex Mercatoria as any law relating to businesses, which was criticized by Professor Julia Stone, and Lex Maritima, the law for merchants on sea. Alok in his recent article criticized this definition to be too narrow, and merely creative. Professor Dodd and Professor Malcolm Shaw of Leeds University supported this proposition. World Trade Organization. In 1995, the World Trade Organization, a formal international organization to regulate trade, was established. It is the most important development in the history of international trade law. The purposes and structure of the organization is governed by the agreement establishing the World Trade Organization, also known as the Marrakesh Agreement. It does not specify the actual rules that govern international trade in specific areas. These are found in separate treaties, annexed to the Marrakesh Agreement. Scope of WTO: A. Provide framework for administration and implementation of agreements. Forum for further negotiations. Trade policy review mechanism. And promote greater coherence among members' economics policies, principles of the WTO: A. Principle of non-discrimination, market access, balancing trade liberalization and other societal interests, harmonization of national regulation, trade in goods. The GATT has been the backbone of international trade law throughout most of the 20th century. It contains rules relating to unfair trading practices, Euro dumping and subsidies. Trade and intellectual property. The World Trade Organization trade-related aspects of intellectual property rights agreement required signatory nations to raise intellectual property rights. This arguably has had a negative impact on access to essential medicines in some nations. Cross-border transactions. Cross-border operations are subject to taxation by more than one country. Commercial activity that occurs among several jurisdictions or countries is called a cross-border transaction. Those involved in any international business development or international trade should be knowledgeable in tax law, as every country enforces different laws on foreign businesses. International tax planning ensures that cross-border businesses stay tax compliant and avoid or lessen double taxation. Dispute settlement. Most prominent in the area of dispute settlement in international trade law is the WTO dispute settlement system. The WTO dispute settlement body is operational since 1995 and has been very active since then, with 369 cases in the time between January 1, 1995 and December 1, 2007. Nearly a quarter of disputes reached an amicable solution. In other cases, the parties to the dispute resorted to adjudication. The WTO dispute settlement body has exclusive and compulsory jurisdiction over disputes on WTO law. See also, World Trade Organization. Category: United States Federal Trade Legislation, International Trade. Notes. References: Van den Bosch, Peter. The Law and Policy of the World Trade Organization. Text, Cases and Materials. Maastricht University, Cambridge University Press. PA 917. ISBN A978-0-521-72759-4. External links: International Bar Association, International Trade Center, a UN organization, Trade Law Center for Southern Africa, World Trade Institute, at the University of Bern, International Trade Debates in Iran, World Trade Organization, WTO, Federation of International Trade Associations. Does sales-only apportionment violate international trade rules? Reports suggesting that sales-only apportionment may violate international trade rules that prohibit export sales. PhDs in Law Without the State, The Spontaneous Emergence of Commercial Legal Order, Georgetown Journal of International Law 41, 559-620.